All right, I will call this meeting of the Senate Judiciary Committee to order. Will the secretary please take the roll?
Senator Flores.
Present.
Senator Orenshaw.
Here.
Senator Lang. Senator Nguyen. Here. Senator Hansen. Senator Krasner. Senator Ellison. Chair Scheibel.
Here, and please mark Senator Hansen present when he arrives. Welcome everybody to Senate Judiciary. We have two bills on our agenda for this afternoon. My plan is to take them in numerical order, if that's okay with the presenters. All right, then in that case, without further ado, I will invite our presenters down here on SB 201. You may not have been in this room since it was upgraded, so I want to let you know that there are two microphones down there. There's a little button that looks like someone dropped a sticker on the table. You have to press that to turn the microphone on, and I'll just remind you to please give your name and spell it for the record before you speak, and go ahead whenever you're ready.
Just a little short. I know.
Thank you so much, Chair Scheibel, Vice Chair Flores, and members of the Committee on Judiciary. For the record, my name is Julie Pazina, representing Senate District 12 in Clark County, and I'm presenting Senate Bill 201, which prohibits certain restrictions on the display of religious items in common interest communities. Nevada's 3,711 homeowners associations regulate the appearance and maintenance of common areas within a community, including things like landscaping, exterior home aesthetics, property modifications, noise levels, pet restrictions, and parking to maintain the overall value and character of the neighborhood. Essentially, they control the aspects of a property that are visible from outside of the home, as well as shared amenities like pools or parks. With oversight of roughly 624,000 housing units, about half of the state's 1.3 million homes, HOAs have a significant impact on how homeowners and renters in Nevada express their personal beliefs. Senate Bill 201 aims to protect and balance residents' rights to freely express their religious beliefs and to exercise their First Amendment rights in HOA-regulated communities. This bill was brought forward to me by my good friend, Elliot Mallon, who will be providing additional comments in just a moment. But to share the bill summary, Senate Bill 201 restricts, with certain exceptions, an HOA or landlord from prohibiting an owner or occupant of a unit from displaying religious items on their door or door frame. Specific exceptions to this provision include any display that's larger than 36 by 12 square inches or that exceeds the size of the door or frame the display is affixed to, threatens the health, safety, or welfare of the public, hinders the opening or closing of any entry door, violates any federal, state, or local law, promotes discrimination or discriminatory beliefs, contains graphics, language, or any display that is obscene or otherwise illegal. This bill does not preclude the creation of rules that reasonably restrict the placement and manner of the display of religious items by a unit's owner or occupant. In instances where a door or door frame requires maintenance, an occupant may be requested to temporarily remove a display if given advance notice. The occupant must then be allowed to return the display once maintenance is complete. If a dispute arises due to the display of a religious item and an action is commenced, the prevailing party is entitled to recover reasonable attorney's fees and costs. And finally, the bill voids any government document, rental agreement, or policy that is contrary. However, we do have an amendment coming, and I believe that Elliot Mallon will be speaking about that in a moment. And with that, I'm actually going to hand it over to him.
Now it's
It
red.
turns red. That
Not
is
green?
when you're supposed to talk. Red like it's a hot mic.
Green makes more sense. All right, good afternoon, Chair Scheibel and members of the committee. For the record, my name is Elliot Mallon, E-L-L-I-O-T, M-A-L-I-N, on behalf of the Anti-Defamation League here in Nevada. First, I'd like to thank you for hearing SB 201 to help protect Nevadans' religious liberties at the most important place to them, their home. I'd also like to thank Senator Pazina for being a champion on this issue and working with us through the interim to address it. This is our second session bringing this forward, and I'm thankful to be here today. You might be wondering why this conversation is even necessary or what this is even about. A few years ago, we started hearing from Jewish Nevadans that they were being told that they had to remove their mezuzah from their doorposts in their common interest communities and apartment complexes. For those of you that don't know, a mezuzah is a small box that is placed on the doorpost of Jewish homes at an angle and is required by Jewish law for Jewish homes. Common interest communities, or homeowner associations, HOAs for short, operate often as a quasi-governmental entity. These typically are required to abide by constitutional protections and law. However, when an HOA makes a prohibition that is content neutral, such as no items at all on the doorframe, that would be facially legal. Further conversation we've had is centered around the Federal Fair Housing Act, or FHA, which prohibits discrimination by direct providers of housing, such as landlords and real estate companies, as well as other entities such as municipalities, banks, or other lending institutions, and homeowners insurance companies whose discriminatory practices make housing unavailable to persons because of race or color, religious, sexual, national origin, familial status, or disability. The FHA also applies to HOAs and rental units and can apply to the application of religious items on doorframes when there is a clear discriminatory lens to the action. The Seventh Circuit in Block v. Frischholz determined that residents of HOAs may file suit against their HOAs if the HOA enacts a discriminatory policy after the purchase of the property, even if it appears to be facially neutral. The District Court in Block v. Friedrichsen, citing Block, stated that the FHA's provisions applies to the post-acquisition discriminatory conduct that makes a dwelling unavailable to the owner or tenant, somewhat like a constructive eviction. To show that constructive eviction, a plaintiff must show their residence is unfit for occupancy, often to the point that they are compelled to leave. When a religious Jewish resident is prohibited from affixing a mezuzah to their doorpost, it would preclude them from their ability to live in that community and in that home. However, there's also been some confusion when seemingly content-neutral prohibitions occur prior to a resident having moved into a unit, which may lead to very expensive litigation. Further, this may cause differences in regulations for residents who were in a unit prior to the enactment of a facially neutral prohibition to post-enactment. What we aim to do here is provide for clear guidelines and protections in Nevada for residents, HOAs, rental units, and others. We are presenting this bill with conceptual amendments, which I hope you all received. I'm going to go through those briefly. The first, under Section 1, Sub 1, insert language, so it would read, a rental agreement must not enforce or adopt a restrictive covenant or otherwise prohibit a unit's owner or an occupant of a unit from engaging in the daily display of religious items. That just ensures restrictive covenants are not in violation of the statute and everything is, for lack of a better term here, kosher. Under Section 2, Subsection 3, the last sentence, insert the word written, so that way it would be provide written notice instead of just provide notice. Providing written notice avoids ambiguity, and it's a protection for both the HOA, the interests of the community, as well as the resident. We would like to expand under Amendment 3, making this applicable to NRS 118A as well, which is what covers landlord-tenant law. Because we know that this is happening in more than just HOAs. We have heard this from Nevadans, that this is also happening in apartment complexes and other rental units. In Section 2, Sub 2, delete the requirements to review and amend as necessary the bylaws and instead refer to NRS 116.1206, Sub 1. From the reading, and LCB can tell me that I'm wrong, but the reading of this section of the NRS, it would permit the common interest community to conform their bylaws and governing documents to NRS instead of requiring them to go through the full process to amend their bylaws, which, as if you live in an HOA, know that one, costs residents money, and two, it can be hard to get all of the residents to vote. So this would allow the HOA to immediately amend the bylaws. This bill does not permit a free-for-all on door frames and doorposts. Instead, it requires the residents be permitted to have their religious items on their property that they have exclusive right to occupy. It does not apply to the display of religious items that are greater than 36 by 12 square inches or that exceeds the size of the door on which or whose frame on which the display or religious item is displayed or affixed. It does not apply to items that threatens the health, safety, or welfare to the public, hinders the opening or closing of any entry door, violates any federal, state, or local law, promotes discrimination or discriminatory beliefs, or contains graphics, language, or any display that is obscene or otherwise illegal. I know that we have received quite a few questions about the size limitations, and some of you have talked to me about that, and I thank you for that. So I want to put on the record what that is referring to. We as Jews are not the only ones that have items that go on the doors or door frames for their religious observances. So while I have a mezuzah, we want to make sure we're protecting all religious beliefs. And so this refers to the smallest possible size for Hindu Nevadans to accommodate what is called a Toran. Torans are colorful door hangings customarily made of mango leaves and marigold, or materials resembling them. They represent cleanliness, clarity, and passion, and are said to attract Lakshmi, the goddess of wealth and prosperity. And so our intent with that size requirement was to encompass and make sure that we protect Hindu Nevadans' rights as well. And that was the smallest size we could find. And this is what they went with in the California statute to do the same thing. When looking at bringing these protections, it was important to us that we not exclude any groups while offering HOAs and landlords the flexibility to regulate certain items that would not conform within the context of this language. Finally, this morning, this is not in the amendment language, but I want to put this on the record. We found out another little thing, so I want to let you know of our intent to under Section 1, subsection 3, to add language to permit temporary removal of an item with notice and no response from the tenant or homeowner, while requiring replacement of the religious item after the maintenance for common interest communities such as condominiums who actually maintain the doors, door frames, paint of the outside of the units, and then require them, if they remove the item, to replace it. Thank you, Chair, and I can answer any questions that you have.
All right, thank you both so much for your presentation. I will open it up for questions from members of the committee, starting with Senator Ellison.
Thank you. This is the last bill that I read last night, and I got a little confused because I was getting a little tired, and my colleague straightened me out this morning. But I do approve of this bill. I think it's great. I think that people have the right for religious freedoms and without being restricted to that. I mean, I'm not talking billboards. I'm talking something small on the door. So, and you see a lot of that during Christmas time in HOAs, that the people put up Christmas lights and stuff, and they come and take them down, or they rip them down. So I think this will help a lot of this that might be addressed, that you can't violate somebody's right. I do have one problem on this bill, though, and I didn't get asked to sign on to it. So
Senator Ellison, Julie Vazina for the record, and we would love to add you to the bill.
thank you very much. Thank you.
Other questions from members of the committee? Senator Orenshaw.
Thank you. More of a comment as well, in line with my colleague from ELCO. I just want to thank Senator Brezina for bringing the bill and Mr. Mallon for working on it. You know, till this bill was brought last session, I didn't realize this was an issue. And thank you for bringing it to all of our attention. Thank you for your work on the bill.
Okay. If there are no other questions, I have a couple of questions about the amendment. I think Section 1 is duplicative, that we already have a law prohibiting the enforcement of a legally disallowable restrictive covenant. So is there a reason that this was included? Can you tell us a little bit about it?
Thank you, Chair. Elliott Mallon for the record. That actually came from Senator Rogage when she read the bill and wanted to sign on. If it's duplicative, then we don't need it.
If I could get legal to weigh in here.
Thank you, Chair. Yes, it is, in fact, duplicative of the Section 1, subsection 1 provision that already prohibits that.
Okay, thank you. And then I had a kind of similar question about proposal number 4 and the changes to NRS 116.12061. And maybe I'm just not understanding the process by which bylaws get changed, but wouldn't this make it harder to update the bylaws and make them conform with the new law?
Thank you, Chair. Elliott Mallon for the record. This actually came from the HOAs who said this would make it easier for them. I'm more than happy to discuss that with them further. The way that they read that, the way that I read that, and I could be wrong, was that it would allow them, if the bylaws are not up to code with, or up to par with what NRS says, to automatically update the bylaws. And I could be wrong again.
I'm going to toss it over to legal again.
Thank you, Chair. What that provision does is it says when the legislature amends Chapter 116, by operation of law, those requirements, whatever they may be, if something is prohibited, it becomes unenforceable. But it's still going to exist in the actual governing documents until such time as it's removed. So if, for example, property sold in the resale package, it'll still have the offensive provision in there. So that's why that transitory provision is included in the bill, to make sure that those things are actually removed and don't continue to exist, even though they are unenforceable if the law is passed.
So, sorry, with the suggestion offered in Part 4 of the amendment, does that still maintain the offensive provisions in the governing documents, or does that allow those offensive provisions to be removed from the governing documents?
I'm sorry, I'm not sure I understood that question.
Would we want to make this change suggested in Section 4 or not make the change in order to have the offensive provisions removed from the governing documents?
In order to have them removed, you would need to not include this amendment in that's marked as 4 and just keep the bill the way it is.
Okay, so certainly something that we can follow up offline about and get some more clarity. Because I do appreciate all the hard work that's gone into this, and I know there are a lot of stakeholders who have weighed in, and I feel confident in saying that we'll be able to get to a place where everyone's comfortable with the language. So I appreciate the hard work you've already done. Look forward to helping you if I can work on it any further. And I don't see any other questions or comments from members of the committee. So thank you again for your presentations. We will move into testimony. We'll start with testimony in support of SB 201 and invite anybody wishing to give support testimony down to the front in Carson City and Las Vegas right now. Please go ahead here in Carson City whenever you're ready.
Thank you, Madam Chair. For the record, Garrett Gordon, representing the Community Association Institute. Just want to thank the sponsor and Elliot Malin for working with us on these amendments. We are now in support of the bill with the amendments. Let me focus on Section 4, Madam Chair, if I may, to address your question in LCB. That specific amendment came from my client because the bill currently requires that if there is this language in CC&Rs, it needs to be removed or clarified before October 1, 2025. I don't know how many CC&Rs this language may be in. There's 3,700 HOAs in this state, and trying to get any of them to amend any CC&Rs with 75% of the vote is expensive for HOAs. And what happens if it's not accomplished? Is there a penalty? So that's why years ago we put in the statute that if the legislature changes the law and the CC&Rs are contrary to that law, the CC&Rs are automatically amended to be in conformance with the law. So to avoid the cost and time of trying to amend, I don't know, thousands of CC&Rs, we thought this was the better route. And I did work with Mr. Malin, and his client agreed. So hopefully that background helps.
I think it does. Thank you.
Good afternoon, Senator Scheibel, members of the committee. My name is Michael DeLee, and I represent a client who has hopefully a little bit of a story to share. Maybe she's able to call in. I hope a little time off of work, but I thought what I'd do is just give you an excerpt from the response that she was given when she asked to put a mezuzah on her door. Respectfully stated, while we understand that the symbol is a religious symbol, please note that your request is denied. Pursuant to the agreement, if your home is accessed by an interior hall, no items are allowed in that common space. This includes entry to your dwelling unit. Please note that these items include, but are not limited to, doormats, wreaths, decorations, or postings of any sort. Of relevance, management expends a great deal of time and resources into the overall aesthetics of the community and does not plan to permit postings at this time. Please be aware that management enforces this policy equally throughout the community for all residents. Sounds fair enough, but we see what the problem is, and that's what this bill is designed to fix. So we look forward to your support. Thank you.
Thank you. Chair Scheibel, Vice Chair Flores, and members of the committee, thank you for the opportunity to testify today. My name is Matthew DeFalco, and I serve as the Government Affairs Director for Olympia Companies. From beautiful master plan communities and friendly neighborhood shopping centers to multifaceted gaming and entertainment destinations, Olympia delivers what communities both need and want. Olympia Companies strongly supports SB 201, which ensures that homeowners and tenants in common interest communities have the right to display religious items on their private property. As developers of communities that emphasize inclusivity and respect for diverse backgrounds, we believe this bill strikes an important balance, protecting religious expression while allowing reasonable community standards to be maintained. SB 201 includes appropriate safeguards to ensure that displays do not pose safety hazards, violate laws, or promote discrimination. Importantly, it allows for reasonable restrictions on placement and size, ensuring that the integrity of our communities is preserved while honoring individual rights. At Olympia Companies, we strive to create communities where residents feel at home and feel free to express themselves within reasonable guidelines. This bill aligns with that philosophy. We urge the committee to support the bill to reinforce Nevada's commitment to both religious freedom and well-managed communities. Thank you for your time and consideration.
Good afternoon. My name is Tia Smith, TIA, SMITH. I'm a policy attorney with ACLU of Nevada. We support this bill and we urge the committee to support it as well. Thank you.
All right, I don't see anybody else wishing to give in-person testimony in Carson City or Las Vegas, so we will go to the phones for testimony in support of SB 201.
Thank you, Chair. If you would like to testify in support for Senate Bill 201, please press *9 now to take your place in the queue.
Hi, my name is Claudia Smith. I'm here to testify on behalf of what Michael Lee has stated. I was a resident at one of the apartment complexes, and I was told to take down my mezuzah, and this really affected me in many ways. I also had to leave my apartment because they were not allowing me to keep this up, and this is a religious symbol for me, which I must have on my door. And I actually got past my first lease with no issues, but going into my second lease, it all of a sudden created an issue, and it wasn't hurting anybody. I wasn't offending anybody. I was just practicing my beliefs. It's just on my door. It's a little piece, a little stick, and I'll support this bill. You guys will support it as well. Thank you.
Chair, there are no further callers wishing to testify in support at this time.
Okay, then we will move to testimony in opposition to SB 201. Anybody wishing to give opposition testimony in person is invited to do so now. It looks like we have somebody down in Las Vegas, so please go ahead whenever you're ready.
Good afternoon, Chair. Senators, my name for the record is Mike Kozar, K-O-S-O-R. I'm speaking in opposition, and I want to make clear my opposition is not to the underlying policy of what is intended here. I am supportive of that policy. What I am concerned with are two items. You have addressed one of them in conversation, and that is the structure and the language of the bill. It is extremely difficult when I sat down and read it, having spent multiple times on multiple boards, to really understand what the statute was trying to say. I say, and reluctantly, because I'm going to point to a California statute, and I rarely look there for guidance, but California has some statutes, 1940 of their code, where they take this exact bill and they word it such that it's extremely easy to understand and read. And that would be useful. It basically allows states what a board may prohibit, as opposed to the way this language is structured, which is rather convoluted with double negatives and so forth. My other point of concern is that hasn't been raised is with Section 4 of the bill, which allows for and permits prevailing party language in the recovery of attorney's fees. And my concern is I see no reason why, if this bill is adopted in NRS 116, that it should not be provided by the provisions already in NRS 116s for addressing a violation of this law. A violation of NRS 116 should first be raised with the regulator. That's the Nevada Real Estate Division. There is a low cost and an expedient system already in place that alleged violations of NRS would be addressed. NRS 116-41117 addresses that. This would provide special treatment for this particular rule. And I just don't see why there ought to be special treatment for this rule over the other rules that are in NRS 116 already. And so there is where my primary objective is. And I'm afraid that this rule, if it's a special rule, would be used to weaponize against homeowners or a homeowner against the association. And I'm sure that's not what the intent of the bill was all about. So I would ask, why are we having special rules? And that would be my biggest objection to Section 4, which is simply eliminated. I'd be very happy with this bill. So thank you very much.
All right, thank you for your testimony. That looks like everybody wishing to testify in opposition in person. So we will go to the phones, please, for opposition testimony on SB 201.
Thank you, Chair. The public line is open and working. However, there are no callers wishing to testify in opposition at this time.
Okay, then we will go to neutral testimony. Anybody wishing to give neutral testimony in person is invited to do so now. And it looks like we do have somebody coming up to the table, a couple of people coming up to the table in Las Vegas to give neutral testimony. Please go ahead whenever you're ready.
Good afternoon, Madam Chair, members of the committee, Sharat Chandra, Administrator for the Real Estate Division, and I also have the Ombudsman.
Good afternoon, Sonia Merriweather, Ombudsman for Common Interest Communities.
Again, Sharat Chandra for the record. The division is here to answer any questions if members of the committee have any. If not, we just wanted to let you folks know that we are here and available.
Thank you so much. I don't see any questions from members of the committee, but we certainly appreciate you coming all the way down just to make yourselves available. That's very, very much appreciated. If there's no questions and no one else to give neutral testimony, we will go to the phones, please, for neutral testimony on SB 201.
Thank you, Chair. The public line is open and working, but there are no callers wishing to testify in neutral.
All right, then if the sponsors have any closing remarks, it looks like they do. Now is the time to come down to the front and make those remarks.
Thank you, Chair. Elliot Mallon for the record. The red light still freaks me out a little bit. I want to mention that I just spoke with Mr. Gordon. We had a conversation to also clarify that Fourth Amendment. If there is no restrictive language in the CCNRs and governing docs, then we're not really concerned about prohibitions. We're really concerned about language that does prohibit. So it should actually allow them the ease of not enforcing them if we were to go with the Fourth Amendment. Further, I did have the opportunity to speak with Mr. Kosar. I don't have the same reading of the statute as him. I don't think that this is duplicative. A few of us went through this. Also, I want to mention that the language from California is actually what we used to draft this one when it was sent to LCB. So thank you, and thank you again. We really appreciate you hearing this today.
And Julie Pizzina for the record, just to thank you again for hearing Senate Bill 201. This was legislation I had desperately wanted to co-sponsor last session. Unfortunately, the bill never got a hearing, so I'm incredibly grateful for Chair Scheibel for the opportunity to present this to the Committee on Judiciary today. As you can hear, there are real Nevadans affected by this, and we thank you for your commitment to helping everyone in the state. Thank you.
All right, thank you so much for presenting us with this bill. I'll now close the bill hearing on SB 201 and open up the bill hearing on SB 203. And please go ahead whenever you're ready.
Thank you once again, Chair Scheibel, Vice Chair Flores, and members of the Committee on Judiciary. For the record, my name remains Julie Pizzina, still representing Senate District 12 in Clark County. I'm presenting Senate Bill 203, which provides immunity from civil liability for certain agencies, entities, and persons relating to the parimutuel system of wagering. So what is parimutuel wagering? It's a question that I would imagine I'm going to get a fair bit with this bill. It's a betting system typically employed for off-site betting on horse racing, where all bets of a particular type are placed together in a pool, taxes and the house take are deducted, and payoff odds are calculated by sharing the pool among all winning bets. Parimutuel wagering works by aggregating all wagers into a common pool and then using that money to pay the winners. Unlike fixed odds betting, parimutuel wagering involves frequent odds changes as the action flows toward or away from individual horses. In Nevada, off-track parimutuel wagering is governed by Nevada Revised Statutes Chapter 464 and Nevada Gaming Control Board Regulations 26A and 26C. The Nevada Gaming Commission appoints the off-track parimutuel wagering committee, and it consists of 11 persons who are licensed to engage in off-track parimutuel wagering. Upon their appointment, the committee is granted the exclusive right to negotiate agreements that relate to off-track parimutuel wagering with persons licensed or otherwise permitted to operate a wagering pool in another state where the race occurs, and persons licensed in Nevada as an operator of a system. Senate Bill 203 aims to provide civil liability immunity for specific government entities and personnel involved in regulating the parimutuel wagering system, essentially shielding them from lawsuits related to their actions in overseeing this type of gambling activity within the state. It's necessary to provide individuals making decisions within the system and encourages effective regulation without fear of personal legal repercussions. So a quick summary, it provides that the state of Nevada, the Nevada Gaming Commission, and any of its members, employees, attorneys, and other personnel, the Nevada Gaming Control Board, and any of its members, employees, attorneys, or other personnel, and the Off-Track Parimutuel Wagering Committee are immune from civil liability for any decision or action taken in good faith and without malicious intent in carrying out the provisions of law relating to the parimutuel system of wagering. For more information on Senate Bill 203, I'm now going to hand it over to Virginia Valentine and then Mark Rubenstein to provide additional comments. Thank you.
Thank you. Good afternoon, Chair Scheibel, Vice Chair Flores, and members of the Senate Judiciary Committee. My name is Virginia Valentine, V-A-L-E-N-T-I-N-E, and I represent the Nevada Resort Association. I'd like to start by thanking Senator Pizzina for bringing this bill, which provides narrow liability protections for members of the Off-Track Parimutuel Association Rate Committee when they are performing their duties. Several members of the NRA serve as uncompensated members of the committee, which negotiates rates the tracks charge the race books to telecast and place wagers on races on behalf of all of Nevada's race books. Several NRA member companies are represented on the committee. Without the PMA's work, there would not be uniform races, a level playing field for books in the state, or fair rates for the books. Race books are a favorite pastime and a traditional element of horse wagering and sports books. Racing's a niche following, and you would find people watching and placing wagers on almost any day in Nevada's race books. This bill does nothing with regards to consumers. It simply provides protection for members of the rate committee while they are performing their essential functions prescribed in state law and gaming regulation. And now Mr. Rubenstein is going to talk about the history and the need for the bill.
Thank you, Virginia. Chair Scheibel, members of the committee, my name is Mark Rubenstein. That's M-A-R-C, R-U-B-I-N-S-T-E-I-N. I'm with the law firm of Reed Rubenstein and Bogatz in Las Vegas, and I'm appearing on behalf of the Nevada Resort Association and the Nevada Parimutuel Association. I'd like to thank Senator Pezzina for the introduction and expand a little on her opening remarks by providing some history and context. In 1991, the legislature created the Off-Track Parimutuel Wagering Committee, which was appointed by the Nevada Gaming Commission and overseen by the Commission, and given the exclusive right to negotiate agreements on behalf of Nevada racebooks with out-of-state racetracks in order to determine the fees that the tracks could charge Nevada books to include their wagers placed in Nevada into the track's parimutuel pools. And with the Nevada Off-Track Parimutuel Systems Operator, which is commonly known as the Nevada Hub, and which directly accepts, aggregates, and accounts for all the wagers taken by the Nevada books and accomplishes the technical feat of including all those wagers in the track's parimutuel pools. The purpose of creating the committee as an instrument of the Commission was twofold. One, to provide a mechanism for all books, large and small, to negotiate a single rate that each of them would pay to a specific track. And two, to protect the books from the threat of an antitrust action by the tracks under the state agency exemption to the antitrust laws. At the time of passage, there were only 17 off-track parimutuel wagering race books in the state in 1991. That number quickly grew to 55 books, which made a committee of all the books impractical and unwieldy. So in 1997, the legislature wisely amended its statute and created a 9-member committee to be appointed by the Commission with the categories that you see in the law today, which were designed to provide for a reasonable cross-section of race books, both large and small. In 2005, the statute was again amended to expand the committee from 9 to 11, where it stands today. Now, it's important to note, as Virginia said, that the committee does not have any function or duties beyond those two just described. Most important to note is that nothing the committee does impacts bettors or their relationships or interactions with Nevada racebooks. The committee is important for at least 2 reasons. First, it puts Nevada racebooks on a more equal footing when negotiating fees with out-of-state racetracks, which have the exclusive control over their products, as well as with the systems operator or hub, which effectively has a monopoly over what it does. The committee also serves to put the smaller race books on the same footing as the larger books, as the law requires there be a single rate or fee charged to all Nevada books for being part of the Nevada system that gets included in the track's pools, and for accepting wagers under the agreements with each specific track. Now, the committee is comprised strictly of volunteers who typically are employed by a Nevada gaming licensee in the position of racebook director or some other position in casino operations that is responsible for the racebook. There's no compensation paid for this position, and the committee does not receive any funding. Most pertinent to this bill, though, is that there currently are no protections afforded to committee members of the nature one would see were they asked to serve on a corporate or charitable board or organization committee. That is, there's no indemnification and there's no insurance. Nor do we foresee either of these things being afforded to the committee by the state. However, because of certain events that occurred over the past several years and the very real threat of litigation by the owners of several major racetracks, the committee members are now seeking this protection. For even if an antitrust action could be defeated by eliminating the state action exemption, the cost of defending such a suit would be enormous and entirely unfair for committee members to have to bear. So what you have before you in SB 203 is proposed legislation that would provide the committee, as well as the state regulators who oversee the committee, with immunity from lawsuit. That's it. That's the bill in its entirety, but it is not without precedent. The language of SB 203 is taken almost verbatim from the chapter on charitable lotteries, which is chapter 462. The only difference between the language in chapter 462 and the language of SB 203 is the inclusion of the off-track parimutuel wagering committee. Thank you for allowing me to present today. I'm happy to answer any questions.
Thank you so much. Before we get into questions, I'm going to ask the question that I think the rest of the committee is afraid to ask, because Senator Pezzina opened her presentation with a definition of parimutuel wagering, but I had to hear it multiple times before I understood it. I'm still not sure I understand it. So could you kind of wrap up one more time just what parimutuel wagering means?
Yeah, parimutuel wagering is a mechanism of wagering that allows the race book or the track to not engage in any risk. So wagers are placed on various horses. All of those wagers are pooled. They're pooled with wagers at the track. The track and the books get to deduct a certain percentage of those wagers as their revenue. And there are also certain expenses allowed to be taken out, such as expenses to pay the tote operators and disseminators and the like, and their taxes taken out. What's left, which is usually somewhere in the 70s or 80%, goes back to the bettors who won their bets.
Thank you. That was very clear. I appreciate it. Senator Pezzina was also clear. Some of us just need it a couple of times. And with that, I will turn it over for more questions from our Vice Chair, Senator Flores.
Thank you, Madam Chair, and thank you for the presentation. And I appreciate the comments, understanding that there may be pending litigation that could create a nightmare. But could you help walk us through hypotheticals so that I could just wrap my mind around exactly what some of these lawsuits look like, what some of these concerns are? It'd be helpful to me just so we can get to exactly what it is that we are concerned that could potentially happen down the road or has been happening. I think you mentioned that for some years now, there's been some conversations that we're concerned about.
Yeah, again, Mark Rubenstein for the record, Senator. There is no pending litigation at the moment. Otherwise, I think this would be somewhat awkward and possibly inappropriate. There has been threatened litigation. And what the litigation that most recently was threatened was an antitrust litigation accusing the industry of being an illegal cartel because they negotiate a single rate with the tracks and don't allow the tracks to go into each of the casinos and negotiate separate rates that might vary. But there's an exception under antitrust law for state agencies to do things such as what the committee is doing as a group on behalf of the entire industry when it becomes an arm of a state regulatory body or a state agency.
Thank you. And Madam Chair, if I may ask a couple more questions. And you mentioned that this is something that we are copying verbatim already when we talk about our charitable arm of some of the stuff that happens at the Vegas Golden Knights games. Is what I'm thinking of, right? Yes. And in that scenario, when we implemented those protections there, were the concerns the same, or were they different? And I was just curious to know. Please.
Again, Mark Rubenstein for the record. I don't know. I did not do the research underlying the adoption of that bill. I'm happy to do so and furnish it to the committee as to what the legislative history was that behind that immunity legislation. But the language is verbatim, except that we added onto the list in 462. You have the same list of bodies and personnel who receive immunity. The only difference is in this bill we add the off-track parimutuel wagering committee because that's a separate entity that was created, and that's the specific entity we're looking to protect.
Perfect. And Madam Chair, if I may ask one more, and then we'll hand it off because I know members have a lot of questions. And for purposes of transparency, because I think it'd be good if that's the concern that we're trying to avoid going down that potential scenario down the road, Can we talk about how the committee now engages in these conversations? Is there transparency there now? Because I get that, we're saying they're a cartel or something. That sounds crazy. Obviously they are not, but I would like to just put on the record why it is that adding all these protections, we're still going to have transparency. We're still going to make sure that none of the fears that are out there lingering can ever actually come into fruition.
Sure. Mark Rubenstein again for the record, Senator. Transparency to a point. The committee is an arm of the Nevada Gaming Commission, and so all of its minutes and so forth are shared, and all of its actions are shared with the commission. So there's oversight of the committee by the Nevada Gaming Commission. Now, whether those records are open to the public, I don't believe so, given the policy that the legislature has adopted over the years of keeping gaming records confidential. But there definitely is oversight by, I think, the body that you would be most comfortable having oversight.
Understood. Thank you for that. Thank you, Madam Chair.
Absolutely. Senator Wynn, did you have questions? Okay, please go ahead.
Thank you. I have a couple of questions. You had talked about the civil immunity, and you kind of got into this. The intent of our current system with this 11 committee member is that they can negotiate, and it really protects some of these smaller sports books. Is that my understanding too?
That's correct, Senator. Again, for the record, Mark Rubenstein. The fundamental reason for the creation of the committee, and again, originally it was a committee of the whole when there were 17 books, was to ensure that all books pay the same rate, regardless of their size.
And so it's fair to say, like, some of the larger books would be able to negotiate, if they were individually negotiating, they would be able to negotiate with some of these, with a pretty famous racetrack that is, controls a lot of this. Is that correct?
That is correct, Senator, and there is some history there, a little bit even before my time, but it's my understanding, I believe Caesar's Palace back in the 80s tried to negotiate an exclusive deal with New York Racing Association, or NYRA, to bring the live broadcasts of NYRA races into Nevada, and that was appropriately frowned upon, and so there were a whole bunch of laws enacted in the 80s and 90s to kind of bring about the fair situation that we have today.
And it's fair to say that this larger racetrack would prefer to negotiate individually so they could perhaps take advantage of some of these smaller books that wouldn't be able to compete.
Senator, again, Mark Rubenstein for the record. Yes, that is correct. They would prefer to negotiate separate agreements so they could leverage each of the books. And one of the ironies was that one of the tracks that was threatening litigation operates more than one racetrack, and as a condition of agreeing to a rate on its largest racetrack, it required the books enter into agreements on all of its racetracks, or there would be no deal, which to me, I'm not an antitrust expert, but on its face kind of smells like an illegal tying arrangement. And yet they had the gall to suggest that somehow Nevada was breaking the antitrust laws, which I found ironic and somewhat offensive.
I tend to agree with you, and this doesn't apply. I think we only have 2 tracks that this is mostly applies to off-track betting. We only have the Winnemucca Mule races and the Elko Mule races. I think those are our 2 tracks that are also governed under this law.
I guess they technically are, but really this law is intended for the NYRAs and the Churchill Downs and the Santa Anitas of the world.
So they're not having trouble negotiating with Winnemucca mule races.
I'm not sure they take action in Las Vegas on the Winnemucca mule races, but I don't want to say they don't.
I think I found the next tourism caucus meeting. Just saying. But thank you.
Thanks.
Questions from other members of the committee? Senator Ellison.
Thank you, Madam Chair. I've got a little bitty one, and I'm just trying to get clarification on the records. The immunity in this bill will only go strictly for sports betting, not into anything else to the Gaming Commission. Is that correct?
Even more narrowly than that, it only goes to off-track, it only goes to parimutuel wagering. So there's a whole giant field of sports wagering and some race wagering that is not parimutuel, that this committee has no involvement in. And again, the immunity only goes to the committee and the regulators if they get sued.
And that's the way I understood you said that. I'd just like to get it on the record. Thank you very much.
Sure.
Other questions from members of the committee? I don't see any other questions, so thank you again for your presentation. We'll now move into testimony on SB 203. Anybody wishing to give testimony in support of SB 203 is invited down to the front table here in Carson City and in Las Vegas right now. And it looks like we have a couple folks coming up in Carson City, so I will allow you to give your testimony whenever you're ready.
Good afternoon, Chair Scheibel, members of the committee. For the record, I'm Michael Alonso. I'm here on behalf of Caesars Entertainment. I would like to take a second to thank Senator Pezzina for sponsoring the legislation, which we believe is very important. Caesars Entertainment is represented on the committee. It's represented from a vantage point of representing Las Vegas, and it's also, as you probably know, owns William Hill, which has race books all over the state. And so it's represented on that committee, and we believe this is an important piece of legislation and hope you will support it. Thank you very much.
Thank you. Scott Gillis with the Griffin Company, representing MGM Resorts International. I want to thank Senator Pezzina for the bill. Just want to echo the comments by Ms. Valentine and the Resort Association, and MGM is in support of this bill. Thank you.
Good afternoon, Russell Rowe here on behalf of Boyd Gaming Corporation, wishing to put our support on the record for this bill as well. Thank you.
Thank you all for that excellent and succinct testimony. I don't see anybody in Las Vegas right now, so we'll go to the phones for testimony in support of SB 203.
Thank you, Chair. The public line is open and working. However, there are no callers wishing to testify in support.
All right, then we will go to testimony in opposition to SB 203. Anybody wishing to give opposition testimony is invited down to the front tables right now in Clark County and Carson City, but I don't see anybody coming to the table, so we will again go to the phones for testimony in opposition to SB 203.
Thank you, Chair. The public line is open and working. However, there are no callers wishing to testify in opposition.
All right, then we will go to neutral testimony. Anybody wishing to give neutral testimony on SB 203 is invited to do so now, but I don't see anybody coming to the table in Las Vegas or Carson City. So we'll once again go to the phones for testimony in neutral on SB 203.
Thank you, Chair. The public line is open and working. However, there are no callers wishing to testify in opposition at this time.
And no one wishing to testify in neutral?
Apologies, yes. No callers wishing to testify in neutral at this time.
All right, then. That concludes testimony on SB 203. And it looks like the presenters don't have any closing remarks, so thank you again for your presentation. I will now close the hearing on SB 203. It was wonderful to have you, Senator Pezzina, as our guest here in Senate Judiciary. We look forward to seeing you again, hopefully very soon. And with that, we will move into the second to last item on our agenda for today, which is a BDR introduction. All of the members should have a copy of this BDR on their desk at the dais. As a reminder, voting to introduce a BDR is not the same as voting for the bill. That is voting for the BDR is voting to have this draft turned into a bill and introduced on the floor for our consideration at a later date. So are there any questions on BDR 3-1021?
Madam Chair, no questions, but I would like to move for the introduction of BDR 3-1021.
Second.
All right, we have a motion from Vice Chair Flores, a second from Senator Orenshaw to introduce this BDR. Any discussion on the motion? Not seeing any discussion. All those in favor say aye. Aye. Any opposed, nay. Looks like by unanimous vote of those present, we will be passing the motion to introduce BDR 3-1021. And that now leads us to our final item on the agenda for today, public comment. Anybody wishing to give public comment in person is invited down to the front now to do so here in Carson City or down in Las Vegas. I don't see anybody coming to the front, so we will go to the phones for public comment.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then that brings us to the conclusion of our meeting for today, and this is our last meeting for this week, right? Okay, I'm just checking that memory serves. We are not meeting tomorrow. We will be back here on Monday, same time, same place. Hope you all have a safe and enjoyable weekend. Until then, we are adjourned.